So welcome everybody, Samantha Reece from the Australian Apartment Advocacy. I'm delighted to have you on board today for this event about management rights, which you will all know is one of my top goals as we come into the next state election. And joining me is the fabulous Jason Carlson from Grace Lawyers, and this is also a passion for him. And so we're going to basically run through a quick presentation, but then I'm going to open the floor to the participants in the room, because I'm keen, obviously, because I represent apartment owners, to get your feedback about how I should be commenting to government about management rights. So I've done the scary thing. I've allowed Jason to actually run with the PowerPoint from his end. So Jason, if we could go to the next slide, please, that would be great. Great, thank you. So the Australian Apartment Advocacy, we represent 2.5 million Australians who live in apartments, and there's 600,000 of you in Queensland. And we do a variety of things, obviously education. We have just created an apartment buyer and owner education kit. We're advocates for you. So next week when I'm in Queensland, I'm meeting with the Attorney General, I'm meeting with Anissa Levy, the Commissioner for QBCC, I'm meeting with the Mayor for Brisbane. And we also undertake research, and of course we'll be going through some of the research that we did with you about management rights, which will be forming part of the submission that we make to the state government about how we change the management rights. And we're basically here as they call me the Erin Brockovich of apartments. I prefer the apartment ombudsman, but I'm a troubleshooter. So if you have issues with your strata or body corporate managers, with your developers, with your builders, I'm the go-to person that you should be thinking about calling. Jason, next slide, please. So that's the education kit. Ignore it, Victoria. I do have Queensland now. And we also do a dedicated apartment awards for excellence, and we'll be launching that in Queensland this year. The reason why I'm telling you as apartment owners is that we actually have a People's Choice category, which is for fantastic body corporates who do amazing jobs of looking after their apartment building and also their residents. And so you'll be hearing more about that as we obviously launch those awards. So I'm going to hand across to Jason now. He's going to take you through his PowerPoint slides, and then we'll kind of like wrap up with myself. So Jason, over to you.
Thank you, Sam. All right. Good evening, everyone. What we're going to look at over the next few minutes is when we come to unpacking management rights, it's important to understand how we got here in the first place. So I'm going to take you through the history of management rights under the Body Corporate Community Management Act. And I'm going to give a bit of a comparison to what's happening in other states and territories across Australia. And then I'm going to try to evenly present the case for and against long-term management rights and see what might stand out for any of you. And then finally, I'm going to look at the positions that have been adopted by others in the industry and what's really driving those positions. Now, the Body Corporate Community Management Act, it stood as the successor to what was known as the Building Units and Group Titles Act, BUGTA, which was introduced in 1980. One of the new concepts that the BCCMA came out with was this idea of different regulation modules for different types of strata developments. So for example, if you had a strata development that predominantly consisted of lots used for commercial purposes, say an office building, then the rules that ought to apply to that strata community should be a little bit different from the rules that apply to a long-term residential building. And that's how we came up with all these different regulation modules. The second module, and indeed the second most used module in Queensland, is the accommodation module. And when this act and the regulation modules were introduced into Parliament, the explanatory note for the legislation described the accommodation module as being significantly less regulated than the standard module. The standard module, of course, being used for any of those schemes that didn't fit neatly into all the other different types of regulation modules. And I've emphasised this part here because this is important. When the accommodation module was introduced back in the mid-90s, the Queensland government of the time said that the accommodation module is intended for schemes used predominantly as holiday letting or or serviced apartment operations under the control of an accommodation manager. And they opine that it would be suitable for hotel or resort projects where the majority of owners are investors. Just continuing on about the accommodation module. Which module applies is largely left to the discretion of a developer. So whoever the original owner of a strata community is, whoever owns the plot of earth that an apartment building is developed on, it's left to them by and large to choose which regulation module is going to apply, but there's a few rules that guide that choice. Now, the accommodation module can apply so long as the lots included in that particular development are predominantly accommodation lots. And I'm going to come back to explain what an accommodation lot is. So that's the first criteria. If they're predominantly accommodation lots, it ticks the box and the developer can select it. Or when the first community management statement is recorded, the lots included in the scheme were intended to be accommodation lots. So the predominant intention was that they would be accommodation lots. So by and large, I've emphasized the word intended because it's left to the intention of a developer. What did they intend when the first CMS was recorded? And of course, when a first CMS is recorded, that gives breath, it gives life to the strata development in Queensland. You don't have a strata community without a community management statement. So what did the developer intend? Moving on, the definition of an accommodation lot under the Body Corporate Community Management Act and its modules, it includes a lot that's subject to a lease or letting for accommodation for long or short-term residential purposes. Or it's made available, or it could be available for use for accommodation for long or short-term residential purposes. Now, one of the key pieces of confusion that I often see in the industry is that people look at that word residential and they say, well, surely that's the saving grace as to whether we're going to be caught under the accommodation module or not, you know, because holiday letting is not a residential purpose. But this is a word that's used in legislation, and it comes down to principles of statutory interpretation. And when the Queensland Civil and Administrative Tribunal looked at this particular issue, they evaluated the meaning of words that are used across the Body Corporate Community Management Act and its regulation modules, and they found that residential in the context of this piece of legislation includes holiday letting or short-term accommodation. So that's really important. What did government mean when they used the word accommodation for long or short-term residential purposes? According to the most recent authority, it means that if someone's using it for a temporary residence for holiday purposes, then that's caught and it can still be classed as an accommodation lot. So where am I going to with all of this? Why am I banging on about the meaning of an accommodation lot? In my view, it's really important because the biggest difference between the accommodation module and the standard module is the total permissible term that's allowed for body corporate contracts such as caretaking and letting agreements. Under the standard module, they're capped at 10 years. No matter what the developer wants to do, if they elect or that they have to subscribe the scheme as being regulated by the standard module, the maximum length of these contracts is 10 years. However, if the accommodation module applies to the scheme or is going to apply to the scheme based on their almost unexaminable opinion, then they can put in place contracts of up to 25 years. And shortly I'm going to talk about what the government's doing when they're reviewing management rights, but certainly one of the issues that's confronting the public policy decision makers in Queensland is, does this difference between the standard module and the accommodation module incentivize developers to choose the accommodation module over the standard module? And indeed, some of you, that may resonate with you if you're living in a long-term residential building, you know, and you think, well, why is a piece of legislation that was intended for hotels and resorts applying to my long-term residential building? Well, it may very well be that the developer was incentivized by this legislative schema to make that the case. Now, some of the other rules that are consistent, no matter whether it's standard or accommodation module that regulates your body corporate, is that to extend or grant one of these agreements under either of these modules, all that's needed is an ordinary resolution. This ordinary resolution has to be determined by a secret vote if there's a letting agreement that's attached to the caretaking agreement. So an ordinary resolution passes if a mere majority of those voters or those owners who decide to vote in favour of it. So, for example, you could have a 100 lot scheme in Queensland. Out of the 100 lot owners, 30 may only bother to show up and vote. If 16 out of those 30 vote in favour of a new 25-year agreement or a 5-year top-up of a long-term agreement, then that top-up or that new agreement is going to be binding upon that strata community. And indeed, those are numbers I very frequently see in my practice. You see a very small proportion of owners who bother to vote, voting in favour of it, and it encumbers everyone for a very long time.
And Jason, I've also been aware from case studies that have contacted me where the caretaker actually lobbies for people to actually vote in their favour, and that they've also accessed the minutes where they can actually then, try and ascertain who has voted for them and who hasn't. And, it's that kind of transparency that we need to be really mindful, right?
Yeah, absolutely. Absolutely. But that transparency is diminished somewhat by the requirement for an extension or a grant of a caretaking and letting agreement, as long as the letting agreement is attached to it, for the extension of the grant of that to be determined by a secret vote. So notionally, people's identities are hidden, but that can only go so far, because the minutes of a general meeting will record the lots that are represented. It'll show those that have voted. And say that the outcome for a motion was, 10 votes in favour, 1 against, and it was determined by a secret vote. Well, if you're in, say, a 40 lot scheme, you're going to know the 11 lots that were represented at that general meeting. So for future purposes, someone will know where the unrepresented 29 lots lay. But even then, there's flaws in the secret voting system. I very frequently, the whole idea of making it be determined secretly is so that you can ensure that the vote is done free and enthusiastically and free of any external influence, so people don't feel as though they're going to be subject to retribution if they vote against it, or even if they vote in favour of the motion. But that doesn't stop a building manager from knocking on someone's unit door, handing them a secret voting paper and saying, by the way, don't forget to vote. I'd very much appreciate your support. Doesn't stop any of that lobbying or politicking within there. But sort of going back to this idea, this tension that builds between long-term residential communities and short-term hotels and resorts or service department operations. Security of tenure for an accommodation provider or an accommodation manager is very important for hotel and resort operations. You're just not going to see, say, Mantra or an Accor say that we're going to invest heavily in establishing this as a hotel unless they've got that security of tenure. But the tension that I've seen develop over the last 10 to 15 years is, do the same considerations apply for long-term residential communities or not? And I think that's going to be the big public policy consideration that the Queensland Parliament's going to have in front of it over the next year when it's looking at this particular issue. So to sort of sum up where I'm going to...
You don't even go to jail for 25 years for murder, and yet we're signing contracts for 25 years with our caretakers or, facility managers, so it just seems like it's out of sorts.
Yeah. But going back to this idea that when they introduced the accommodation module, that they expressly said in 1997 that it was intended for holiday letting or service department operations. I think if that intention played out in the legislation, we probably wouldn't be having this conversation right now. If someone invests in a hotel or a resort, there's an element of sophistication in the decision that they're making. right? And very few people consciously make the decision of, you know what, I'm going to go and I'm going to purchase that room in that hotel or in that resort, and I'm going to make it my long-term residence. It doesn't really happen that way, right? But because the definition of accommodation lot extended to, you know, accommodation for short or long-term purposes, what it really captured was the investor owner market for long-term residential purposes. So those people that say, I will buy a unit in a long-term residential building, but I'm buying it for investment purposes. I'm buying it as a rental. Now, it's those long-term rental properties that can flip, Sam, between resident owner and investor owner, but they're still being used for long-term residential purposes. So you often see strata communities out there where the majority of lots are rented for long-term residential purposes, and just in a few years that can flip the exact opposite way, and then you've got a building that predominantly consists of resident owners looking at whether the management rights model is appropriate for what their strata community has become. So the question is, why did the actual form of the legislation depart so radically from the intent? Because the intent is there. The accommodation module was intended for holiday letting or service department operations. So why do we see the accommodation module applying to long-term residential buildings that consist of a mix of long-term renters and resident owners? Well, to answer that question, and indeed to inform what's going to happen across the industry over the next year or two, you need to think about who governments consult with when they're looking at changing legislation. One of the people that was consulted back in the mid-90s was a lawyer by the name of Gary Bugden, still in practice. He was consulted by the then Goss government on why their intended improvements to the preceding legislation, the Building Units and Group Titles Act, you know, they did an amending act to it to try and refresh it. They introduced that in 1994, but they were very unpopular, and it came under attack from all corners of the industry. So Gary was brought in by government, and they said, why is this so unpopular and what should we do? It was Gary that recommended to the government this modular approach. And in Gary's own words, he advised the government that the service department regulation would be reserved for schemes without resident owners and would allow long-term management agreements. Now, he explained in a paper that he produced, and if you're interested in the paper, I've got the reference for it here. He explained in this paper, when he was explaining this modular framework to our legislation, that what was intended didn't come out into the reality of what the legislation became, because that final product was different to that original concept, mainly because industry bodies consulted throughout the process had their own objectives and vested interests in it. That's something to very much bear in mind, because you've got to think about who is government listening to and who are they consulting with when they're looking at what's in the best interests of the strata industry generally. And I typically find that the loudest voice in that room tends to be the one that breaks through, grabs the ear of government. I'm going to say more on that shortly. So we've existed with the BCCMA now for 25 years. Its 25-year anniversary ticked over a few weeks ago. And a lot of people say, why in the 21st century do we still have 25-year management rights agreements in Queensland when this legislation's been going for 25 years? We reflect and look at what's happening in other states and territories, particularly on the East Coast. New South Wales changed radically more than a decade ago. In New South Wales, if a developer puts in place a service contract, that contract comes to an end at the scheme's first annual general meeting. And then even then, the owners within that body corporate, what they call an owners corporation down there, the owners corporation is restricted from imposing a service contract on itself that exceeds a term of 10 years. So there's those two restraints. They've stopped developers from imposing long-term agreements in new developments down there, and they're stopping owners corporations, bodies corporate, from imposing a contract on themselves for any more than 10 years. In ACT, it got even stricter. In the ACT, developers were prohibited from using the control that they have over a development that they bring into being by putting in place a service contract of more than 10 years. But if there was something unique or a unique proposition that their development offered to people, they could put in place a service contract for more than 2 years. But they have to convince an independent tribunal, the equivalent of the Queensland Civil and Administrative Tribunal, that the terms of that long-term contract are reasonable. Down in Victoria, they were a little bit slow, but they've certainly had an uptake. Less than a year ago, in December 2021, Victorian government introduced legislation that banned developers from imposing contracts of more than 3 years on strata communities if they're going to profit from them, unless it's for a resort or a hotel. And that's important because the legislation specifically said that it's applying to service contracts that developers will profit from. If they're going to profit from the sale of a service contract for more than 3 years, it's not going to be allowed. So notionally, if you flip that around in the Victorian government's mind, they're saying, well, why would a developer impose a service contract for more than 3 years unless they're going to profit from it? And this comes back to what I think the Queensland government's going to have to confront over the next couple of years. Who is incentivised to put in place long-term management contracts in Queensland bodies corporate? And does the legislation need to be changed to remove that incentive? Are 25-year agreements, particularly in long-term residential strata communities, serving the best interests of that strata community, or are they serving someone else's best interests?
Well, Jason, you may argue that's another revenue stream for developers. Is that correct?
I don't need to argue it. I can tell you as a fact that it is a revenue stream for developers. And the reality of the public policy debate, Sam, is they will come out very openly and acknowledge that it's a revenue stream for developers. And they will say that without that revenue stream, the building and development industry in Queensland will collapse.
That's not correct. And we know that. You know, with the games coming, like that, you know, apartments are a major income source in their own right. There's no need to put the cherry on the top, so to speak. Do you think?
Rhetoric and propaganda does not stand in the way of good facts, Sam. So it'll be interesting to see how it plays out. Yeah, just to sort of sum up, we've looked at what's happened recently in Victoria. We've looked at what's been in place in New South Wales for a very long time. We've looked at the approach that the Australian Capital Territory has taken on this issue. Where are we now in Queensland? What is the Queensland government going to be looking at? At the moment, 10 to 25 year terms are permissible for any type of service contract. This is an important thing to remember. Most people think that it's only management rights contracts that can go up to 25 years. No, that's not the case. It can be for any type of service contract, the provision of services to lots or common property that the body corporate's a party to. So, for example, there could be a 25-year lift maintenance contract imposed on a residential strata building. I see them occasionally, but I don't see them often. And when you speak to the average committee and you tell them that if they really want to, they could enter into a 25-year lift maintenance contract with Schindler, with Coney, with ThyssenKrupp, whoever it might be. You've put that on the table. You say you could enter into a 25-year lift contract. What do you think they say, Sam?
No.
Why would you?
Why in the world would I enter into a 25-year service contract with a lift maintenance company? But
well, it's also cleaners, it's pool cleaners, it's the whole thing, isn't it, Jason? It's not just, you know, so you're right, it's actually any type of service contract.
It could be any type. but I don't typically see 25-year pool cleaning contracts in strata communities or 25-year landscape maintenance contracts outside of a management rights model. You know, you don't often see the 25-year lift maintenance contracts, and you don't see it because when the average person is confronted with the proposition of a 25-year contract of that sort, it just seems so adverse to rhyme and reason. So they say no to it. So although it is possible to have 25-year service contracts for all different types of services, you see it prolific in the management rights model, but not outside of that. And I think that speaks to the culture that we have within Queensland strata industry.
I agree.
The other thing, in terms of where we are in Queensland, the government inserted into the Body Corporate and Community Management Act a provision that creates a near indestructible security interest in favour of any financier of these contracts. So if I wanted to go out tomorrow and establish my own law firm, and if I didn't have a sufficient amount of working capital and I had really grand plans and I wanted to hit the ground running, right? Carlson lawyers, I might realise that I may need about $500,000 in working capital to get that law firm running in the direction that I want from day one, right? I'd want a secure office premises, I'd want a whole staff in there, and I'd want working capital for operating expenses over the first 6 months until I could be guaranteed of an income. If I walked into a bank, Sam, and I said, would you lend me $500,000 so that I can start this business or acquire another business, right? Invariably, they're going to say, where is your security for that? When it comes to lending on management rights, the security is inherent in the contract itself.
The term, yeah, correct.
Without Section 126, if a caretaking agreement was terminated, then the security interest of a financier who lent on the acquisition of management rights would disappear overnight. It's like a mortgaged house that gets blown away in a cyclone and it's not insured for full replacement value. The security interest of the bank that gave the mortgage dissipates overnight. To avoid the destruction of a security interest, you have Section 126 in favour of financiers. You don't see that anywhere else. I challenge anyone to find any area of Australia's wide economy that provides that sort of protection to someone that lends money on the acquisition of a business.
Well, I guess it's the surety of it and the longevity of it, plus also the ability to top it up, right? It's like an ongoing cash cow.
Absolutely, and we're going to come to that. We're going to come to that security interest and why it's there. But you know, the whole idea of 10 to 25-year agreements, indestructible security interest in favour of financiers, it's balanced against this legislative schema of disclosure. The whole idea that people have to disclose, developers disclose the terms of these contracts to people that are purchasing off the plan. Anyone that's buying an existing unit can go in and do a books and records search, and they can discover for themselves the precise terms of these caretaking agreements. And then there's other consumer protections in the legislation, like statutory reviews within the first 3 years of these service contracts being thrust upon a community. Balanced against that, but I'm going to talk about that balance a little bit later. Some of you might be shaking your head about why Queensland's so out of touch with what's happening in other states and territories, and indeed in other parts of the world. Well, that hasn't been lost on Queensland governments. More than 10 years ago, the Office of Regulatory Policy issued a consultation paper on the topic of management rights. And it went out to the public, whole range of questions. What do you think about management rights? What do you think about the total term? Is it too difficult to enforce these duties? You know, is this still appropriate for long-term residential communities? It attracted more than 200 submissions. This was more than 10 years ago. You might be saying, well, what happened to that review? Well, the Queensland government changed in 2012. And the new Attorney General shut down that review that had been started by the Office of Regulatory Policy. And in shutting it down, the new Attorney General said, it's a good system, Other states are looking to copy the Queensland model, and caretakers need financing for their business need to have secure long-term contracts. Before he entered politics, that Attorney General was a management rights lawyer.
Well, that's not the case with the current Attorney General. I can say that, which is a good thing, right? There's an appetite for change.
That's right, absolutely. But, there are two sides to this debate that's going on. You're hearing from me, I'm an advocate for one side of the debate. I'm sure you will hear in the media, in discussions within your own strata communities, just from your own research, you're going to hear the other side to it. And the other side is very much on the idea that buildings need the stability of long-term management. Every year the committee can change. Every 1 to 3 years the strata manager, the body corporate manager can change. On this system, you'll always have long-term management rights centered around a building manager that will provide that stability. They go on to say that, well, hey, the management rights operator is the biggest investor in the entire community. They want the community to work. They want what's in the best interest of the community because it can affect them, being the biggest stakeholder within there. And I alluded to this earlier. Developers are very open on the sale of management rights being a revenue stream, a profit component to it. And they say that it gives them the ability to keep unit prices low and development feasible. And a lot of them will talk about the consumer protections that are out there on the duties on developers to make sure that these terms are fair and reasonable, and giving lot owners the ability to sue a developer if they suffer loss because a service contract's not fair and reasonable. I've never seen that remedy taken up in 25 years by any Queenslander that invests, that runs into inequitable management rights contracts. And when it comes to the topic of top-ups and extensions, it is the body corporate's choice, right? No one's entitled to add another 5 years to a contract. It takes two to tango, and it's for the body corporate to say yay or nay to a top-up. And of course, there's the argument that Queensland's unique. Who cares what the New South Welshmen are doing? Who cares what Victoria has done recently? And there's only 2 buildings with strata in the ACT. Apparently, Queensland's unique, and that's why we have our unique system to management rights. Now, I don't want to go over the other side of the equation. All I will say is that for many years, it's been a question of this perception that lot owners, committees no longer have control and never had control of the largest item of expenditure that they confront, and that any scrutiny on it is just token at best. I was in a meeting with a committee and a large group of lot owners that wanted to talk about management rights. This was only 3 months ago. And I noticed that on the agenda of their last AGM, they'd approved $850,000 in a lift refurbishment contract. And I could see from the way that it was presented. Yeah. Sorry, Sam?
That's a lot of money. How many lifts were there?
Oh, there were a few. It was a big building.
Okay.
They spent a lot of money on these lift refurbishments. And I just said, look, before we get on to management rights, can you talk me through what you did? I'm interested. What did you do? Did you get a project manager? And they explained the story. They engaged an independent project manager who assessed the condition reports of their existing lifts, came up with a scope that went out to tender. They went to 4 or 5 different lift companies. They got competitive tenders in. They then went to work on the 3 best ones. And then when they were comfortable to put 2 up, when they'd played them against each other and they found the 2 options that presented best value, they gave those 2 options to lot owners in general meeting. And then the lot owners chose the one that presented the best value. I said, great. At the same AGM, you also approved a 5-year top up on your management rights. And by my calculation of the annual remuneration, you committed to spending $850,000 of owners' money without it being indexed in 15 to 20 years' time. So notionally, it's the same level of expenditure that you're committing to. Could you tell me who ran your tender for that Oh, we didn't have anyone. All right. Did you guys take any advice from a project manager or a lawyer or a consultant of any sort on the terms of that 5-year top up? No, not really. They just put the motion on, and they asked for our support, and they told us that we needed to support their sound management of the building. So that's what we did. And I just put it to them, why are there these two very different approaches? And the answer, I think, is that you don't have a representative from TK Elevators or Coney or Schindler or any of them in your building, at your committee meetings, in your face, door knocking, looking for support, taking people out for dinner, buying them Christmas presents. You don't have this behaviour out of any other supplier of services to a strata community, but you do for management rights. So it's a very different context that people are making these decisions in.
That was a great
One of the other big
comparison.
issues that
was a great comparison, Jason.
One of the other big
Sorry.
One of the other big issues that I see is committees feeling as though it's futile to even consider attempting enforcing a caretaking agreement. You know, management rights lawyers publicly warn of the bloodbath of bodies corporate through the Queensland Civil and Administrative Tribunal that have tried to enforce these caretaking agreements. So they just say, well, what's the point? And a lot of people that are advocating for small changes to management rights law in Queensland say, well, we need to take care of the bad apples. We need to make it easier for bodies corporate to terminate. I can assure you that if you introduce more legislation to notionally make it easier to terminate caretaking agreements, if there were shares publicly offered for sale in Grace Lawyers, I would encourage you to purchase them, because the value of my law firm will skyrocket if you do anything to try to encourage a greater degree of caretaking disputes and attempts to terminate them, because there will be very few winners, and the few winners, you're probably looking at one of them if that's what happens. The reality is that you do not see vicious litigation over the attempt to end the supply of services from any provider other than a management rights operator. You don't. Many of you here in tonight's webinar have probably been through your fair share of strata managers if you've been a committee member for a few years. The way in which you depart a working relationship with the strata manager is very different from the way in which you might try to depart a working relationship with a facilities manager or a building manager or a resident manager or a caretaker. It's very different because the total possible term of a strata manager is 3 years. If you don't like them after a year or 2 or 3 years, you can go to the market and you can find someone that you can work with. And in fact, the strata manager after 3 years may not like you. They might think that you're the problem, and they would be happy if you went to the market to find someone else, because there are other fish in the sea for that business to service. This is the case for any other supplier. And indeed, you reflect on what you do within your own homes. Could you imagine the uproar that it would cause for the average Queenslander if the only company that was able to clean your living room floor was someone that was provided essentially through the building? Of course not. That's your home. You'll decide who's going to be in your home. Thank you very much. But there are different considerations and different attitudes and beliefs. Indeed, a very different culture when it comes to management rights and its place in the Queensland strata economy. So to wrap this up, before I hand back to Sam, talking about what's going to drive other people in the industry. Before I move on to that, just a reminder, previous. The status quo, those who say that management rights work, look on the left side of the ledger. That's what they're saying. That's what they're going to be saying publicly. I'm going to show you what they say internally when they're looking to lobby for support from the people that buy management rights businesses. Story is very different. They're not talking about what's in the best long-term interests of strata communities. They're talking about what's in the best interests of the value that they have in the businesses. They're lobbying people on the basis that, you know, there's only a few bad apples in the industry that let us down. If we didn't have these bad apples, consumers, lot owners wouldn't have any problem with the idea of 25-year management rights contracts. And importantly, they're telling them to get loud. They're telling them to lobby their local MPs to stop any attempt to water down or to change anything in the legislation that could water down or affect the value of management rights in Queensland. That's what they're doing. And again, they're very overt when they think that they're talking within the same tent. Australian Resident Accommodation Managers Association in Queensland, their CEO, less than 2 years ago, lobbying to members, to people that own management rights businesses, says that his biggest battle is to do nothing. What he means by that is to keep management rights legislation exactly the same. He says that it seems that every 7 years or so, that management rights legislation is under attack from attempts to water it down in the interests of consumers, but to the detriment of management rights operators. It's his role to advocate for that business model, even though it's not popular. And it's his priority to protect those management rights laws with a deliberate strategy to keep the laws the same for the benefit of the management rights business. I can assure you that the lobbyists for management rights have been very vocal, very sophisticated, and very well resourced for the last 25 years. That is why the laws haven't changed. It's the way the industry's worked. But we're entering into a very different phase of Queensland's strata industry and its strata economy. About a year ago, Queensland's Attorney General openly in Parliament acknowledged that they'd establish a community titles legislation working group to look at a range of important body corporate issues, including management rights. Public acknowledgement a year ago that they were going to look at management rights. A couple of weeks ago, the peak industry body to the strata industry, the Strata Community Association of Queensland, announced its position. It's the first time in decades that it's taken a position on management rights. And its position is that service contracts, new service contracts established by developers, should be limited to 3 to 10 years, depending on the module that applies. And you need to tighten the application of the accommodation module so that it only applies to hotels and resorts, no longer to long-term residential communities. And indeed, developers should simply not be allowed to establish long-term contracts that they're going to profit from. But importantly, for existing schemes with existing contracts, that association's not advocating for the reading down of those contracts or them being torn up. But for those existing contracts, the threshold to approve a replacement contract or an extension of it needs to be lifted from an ordinary resolution to a special resolution. So I said earlier that an ordinary resolution passes if a mere majority of those owners who bother to vote in favour of it. A special resolution only passes if those who bother to vote in favour and they represent a 2/3 majority of voters, and so long as the owners of 25% of the lots don't vote against it. So the position that they're advocating for these existing schemes is that if the owners of 25% of the lots in the scheme don't think that a long-term management contract is in their best interests, probably best not to thrust it upon them. And indeed, special resolutions are required by the legislation for a whole range of important decisions. And in fact, some decisions that pale in comparison to the importance of a 25-year management contract. For example, to start a legal proceeding other than the recovery of a levy or in the Commissioner's office, you need a special resolution. To lease or license part of the common property, even for a short term, you need a special resolution. For the long term, you need a resolution without dissent. They have these, and even to borrow for a body corporate under the accommodation module, For it to borrow more than $250 a lot, they need a special resolution. But for it to encumber itself with a 25-year agreement, ordinary resolution is what suffices for that. So we're going to start to see industry associations come out with different positions. Some people will call them extreme. I think SCA's position is rather balanced, and a lot of people would criticise the SCA for not going hard enough, particularly for existing schemes. But I think that represents the middle of the road, and the SCA is saying that their position is intended to bring management rights in Queensland into the 21st century, catch up with how it's being practiced and developed in other states and territories. So that's all I've got for my segment, Sam. Hand over to you.
Thank you, Jason. As always, so succinct. And obviously, Jason sits on the board of the Strata Community Association in Queensland. What we're going to do is just run through a couple of things myself, and then I'm going to open the floor because I do want to hear from you, because I actually represent apartment owners. And while there may be lobbyists like Arama and so forth, what people have not anticipated is that there's 600,000 apartment owners in Queensland, and you represent voters. So while Arama may lobby, at the end of the day, it's the apartment owners that actually have a voice that I want to activate, and that's my focus over the next 12 months as we lead into the next Queensland state election. But I do know that this Attorney General, having spoken to her policy advisor in March, and we're meeting with them again next week, is very much about overhauling the management rights. And I think, as Jason has explained, 25 years ago or 7 years ago, we didn't actually have these changes happening in other states, did we, Jason? And we do now. So no. It's clearly showing that times are changing. So we actually did some research ourselves late last year, and we interviewed 210 Queensland apartment owners, very much on par with the number of people who actually responded last time the management rights went out to public comment, Jason. 75% of the respondents were on the committee in some way, shape or form. 25% had had management rights for longer than 25 years, 37% between 11 and 20 years, and 26% between 3 and 10 years. 96% had management rights in place when they purchased, but 22% were unaware of what that meant. And I think that's the key thing, is a lot of people who move from a home into an apartment, there's a lot of things to consider, right? And management rights is one of those. Only 30% would feel comfortable buying an apartment with management rights in place again, and those 30% were investors. So they were looking for someone to actually manage the property. In most instances, management rights represent 25% of the admin budget or greater. And I've heard of case studies where the caretaker's receiving a salary of $300,000 with no job description, no KPIs, a guaranteed 5% increase per annum, which means that in 10 years' time, they'll be on a salary of over $500,000. I think that's more than any politician earns in this country. And they make far bigger decisions than our caretakers do about the building in which you reside. 60% indicated that a top-up had been approved, and in the majority, it was voted in by a minority, as what Jason was talking about. And 57% of respondents had fallen in dispute with the caretaker. And I think that's, you know, we're not talking about one or two bad apples here, Jason. You know, 57% had fallen in dispute with the caretaker. So that's the majority. And I think that's the problem we have here, is that Arama and those kinds of, you know, industry bodies and developers will try and minimize the impact. But what they're forgetting about is the apartment owners who are living with the repercussions of these long-term management rights. So if you could please go to the next slide, Jason. So what needs to change? So from our perspective, and I'm open for you to comment on this, so once I do finish going through this, please, if you have something to say, unmute yourself and say it. Just be mindful that we don't want to have a plethora of conversations all at once. But like SCA, we believe the contract should be between 3 and 10 years. It needs to be licensed. It needs to be regulated. Like, this actually needs to be seen as a profession. not something where one person can kind of like think they work 1 day a week and yet they can take a salary of $300,000 and not be held accountable. There needs to be a firm job description, hours of duty, and KPIs. You know, I sat in a meeting the other day where a young woman had a situation where her apartment building had been broken into, and the building manager said to her, I work from 9 to 5, Monday to Friday. Don't call me on the weekend when these break-ins were occurring. And then, would you believe it, he actually made a complaint to his manager about her bullying him. So we had to have a grievance meeting with a lawyer involved, and I was there as her advocate, and I couldn't believe it. It was just like, you know, you can't pull the bully court card because we're actually holding you accountable while you're taking this kind of salary. For me, it was outrageous. It only should be introduced in a situation where short stay is the predominant use, and that would be for me like a 75% or higher. The buyer disclosure needs to be provided as part of the sales contract. It needs to be also shown as part of the budget items so people do know what they're buying into. And there needs to be ability to conclude the contract if the building moves to a higher ratio of owner-occupiers. So is that a 50% owner-occupier or is that a 60% owner-occupier? But we need to know at what point do you as owners have that right to actually conclude the contract. We need to have the top-up needs the majority vote, as Jason said, and there needs to be a complaints framework for non-performance and bullying behaviour. Because at the moment, what we're actually seeing is that, you know, if there is bullying behaviour going on, there's no way to complain unless you come to me. And that's, you know, I still have some power, but we need to actually have it backed by government. So there needs to be some kind of formal ombudsman. And if the strata company ceases, and I do have this situation of a number of situations where the building will only last another 5 or 10 years, and the management rights is for 25 years, which means that those owners will continue to pay the management rights even though they're no longer residing in a building. And that needs to also be married up. So these are our points of view, which we will be writing to the government about. But if you have anything else, please raise it with me now or write to me by email. But does anyone have anything else they would like to add? Richard.
Richard here, can you hear me?
Yes, we can.
My name's Richard, can you hear me? Can
Yes.
I ask a couple of questions, please? On one of the slides, Jason, you put down bodies corporate need to consent to any extension, so it's their choice. But earlier you said, you cited about those that needed to attend at an annual general meeting or whatever to make that vote. So what control does the body corporate have the finite decision in its capacity? It doesn't, does it?
So there might be two things, and I'll draw the distinction there for you, Richard. When I talk broadly about an extension, I'm talking about a motion put to a general meeting to authorise a top-up to add another 5 years. But then when that top-up or that option for another 5 years is already in a contract, they'll be exercising that option to extend it for another 5 years. So you need body corporate consent by ordinary resolution in general meeting to give them another 5 years onto the total term of the contract. But once you give it to them, invariably the way those options are crafted is that they're in favour of the caretaker and they just have to give prior notice that they want to exercise that option. And that does not necessarily need body corporate consent. It depends upon the way that the option is worded. And most of them are just to the discretion of the caretaker and they invariably exercise them.
Thank you. And the other one was this, what needs to change going from 3 to 10 years being talked about and recommended. What happens to the existing contracts of 20 years? What's going to happen to those? Will they just have to play out and this will be only for new people?
On SCA's position, yes. Changing the total permissible term to 3 to 10 years would not apply retrospectively to existing contracts. And that's why I describe SCA's position as balanced, because there are a lot of people saying, well, you know, others who want to change to the status quo just want to tear up existing contracts. And yes, those people do exist, Richard. I'm not one of them. There are mums and dads out there, Queenslanders, that have paid hundreds of thousands of dollars that are mortgaged to financiers. And if you just destroy their business overnight, they're going to be in a lot of pain. So trying to come up with a better way, and I always say that when something changes, particularly like through a negotiation, there are no winners and losers. Everyone walks out having taken something and having given something. No one's entirely happy. And I think the SCA position represents that. But for the existing contracts, the thing that's important there is that any extension or putting a top-up option onto them would need approval by special resolution, right? So a lot of what Sam's spoken about here is, you know, complaints for framework about non-performance, bullying, you know, better job descriptions, KPIs. I think all of those things are important. But the position that I personally advocate for is a minimalist one. Don't intervene too much into the market. If you make it harder for building managers to secure a top-up, they will probably work a lot harder for that top-up. At the moment, there's this awful practice happening in strata communities that when a committee comes out vocally and recommends that owners vote against an extension, and all the building manager does is bide their time, start quietly lobbying on the side, start creating new issues to talk about and work to secure a new committee. And they also rely upon just the natural attrition that exists in strata communities. All it takes is for someone's wife or their husband to say, I would like a 3-bedroom apartment rather than a 2-bedroom one. And there you could have a very influential owner that's very passionate and very organized, no longer a part of that strata community because they had to move down the road as a result. So they just bide their time knowing that they just need a mere majority of those who bother to show up.
Thanks, Jim.
Now, I'm a little bit less diplomatic than Jason. And I think that if you have a term of contract that's longer than 10 years, that you should not actually be asked for a top-up, that it should be able to actually run down, right, to below the 10 years. So I would be of a stance asking for government to not allow for those top-ups to occur if the contract is currently above 10 years. But I would also be inclined to push that if you are a majority owner-occupier and you don't actually need the services of a building manager, that an agreement could be reached between the owners and the building manager about a payout system, which could then basically deplete over time. So because my background and my focus is not necessarily the same as SCA's, obviously, right? Our focus is about apartment owners who are paying, you know, so much money for building managers, and in a lot of instances without any kind of real value for money. So for me, like at this stage, and that's why I'm happy to provide your feedback and comments, this would be the stance that we would take. Now, Arama's going to take one stance at one end of the spectrum. We're going to take a stance at the other end of the spectrum. SCA will be in the middle, right? It's about how we actually move the government more towards the middle, if not 60 to 75%. And that's where our role comes into play, and also SCA's. What's your thoughts? Now it's not the time.
Sorry, is that for me or for Richard?
No, it's for well, anybody who's an apartment owner in this room. Now is not the time to be quiet.
Well, the reality is, if there is an agreement up to 25 years, basically you're lumbered with it. And as much as you'd like the parties to be happy and content, there will be conflict and it has to be managed. One would like to think on both sides, but it can be very difficult, especially if the actual agreement is so poorly written, as I'm sure many are. So that's the issue, I suppose, that we have is facing up to the reality of what can be done to come up with any of these options that's going to bring about change.
That's a good point. Linda, give me a sec. Richard, I think that then would we actually ask that all agreements be reviewed currently and brought up to kind of like modern day standards in terms of expectations? So even if you are lumbered with that longer term contract, there are then obviously expectations around job descriptions and KPIs. So they would actually then have to be, I guess, retrofit.
But they have an agreement. they have an agreement in place already. They're not going to want to sacrifice those things. I mean, we do, but why would they? They've got a very comfortable arrangement as regards their lack of KPIs or our expectations. That's the difficulty. Wouldn't it be nice if we could say, let's do that? But the reality, I don't think will allow it to happen.
Well, I would like to be putting that in there. Alison, what do you want to say?
I was just wanting to ask, you were saying that some owners might not want to have a caretaker there anymore. At what point, how do you know that that's what is wanted in a building?
Well, I think that's where Jason was talking about the need for the special resolution. So if you decide that you would like to actually have the caretaker continue, you would actually have to have the 2/3 majority votes, right, to actually go ahead and actually keep that situation occurring.
Okay, all right, thank you.
Linda, did you have something that you wanted to say?
Yeah, Linda Bardsley, Hedge Bedina. I think Jason and Sam, you're well aware of our building. Owners purchased in 2018-19 as a residential only building. The developer then proceeded to sell the management rights to a hotel chain, and the council obliged them by changing the module. So we now have a 25-year contract with them. We're currently going through a caretaker's remuneration. It's now gone to sort of mediation to get to that point. The monetary figure is one thing. The other issue is that the management agreement is not being fulfilled. So I guess the question is probably a few questions, but one being, what is the position when it comes to trying to terminate management agreement? We're being told as a committee that that's near impossible. I think, look, what you're talking about, Jason, moving forward sounds incredibly positive, but I guess possibly a lot of people who are listening today who are looking at a body corporate who are under 25-year agreement, where really the person with the management agreement has other interests, and they're in there to make money and to grow a hotel chain. What do you believe can be done, Jason? Is that possible?
Yeah, at the moment, the conventional way to terminate a caretaking agreement is to issue a remedial action notice specifying duties that they've failed to carry out, misconduct that they've committed, or negligence that they've been guilty of, and giving them an opportunity to remedy that breach. And if the breach goes unremedied, then the body corporate may have a right to terminate. But I'll just bring you back to that concept that I introduced earlier, Linda. Section 126 of the Act, if the contract is financed, if they purchased with the assistance of a bank or another financier, then it makes that interest in the agreement near indestructible based on how it's crafted at the moment. So a lot of the time when people go into performance management, what they're really talking about is if they're not keen to gear up for expensive litigation, then trying to do what they can to force a transfer of the agreement or show that it's in their best interest. But going back to that former in terms of expensive litigation, it's really interesting when you look at the statistics of caretaking disputes. At the moment, the Queensland Civil and Administrative Tribunal holds exclusive jurisdiction over the resolution of caretaking disputes, and they've held that jurisdiction for more than 10 years now. When you look at all of the disputes that have gone before the tribunal that goes down to performance, there's only been one case in the last 12 years where a body corporate successfully terminated in the tribunal's eyes. All the others have been failures or they've been overturned on appeal. However, when you go out into the court system and you look at the district and the Supreme Court, the margin becomes somewhat closer to 50-50. Now, Linda, I can't tell you why that is the case. It just seems really strange that 50% of the time a body corporate can win in a different sort of jurisdiction than what they would in front of a tribunal. I think that's something that someone needs to grasp with. But at the moment, the difficulty is that caretakers have millions of reasons in which to fight against an attempt to terminate their agreement. I think with the natural effluxion of time, if you can do something about improving new developments and you make it more difficult, more onerous for people to extend existing contracts, those millions of reasons may only become hundreds of thousands of reasons. And you may take the commercial incentive of litigation out of it. And in fact, that's why I advocate for making it more difficult to extend them, because how often does someone sue or viciously fight and litigate against someone that they're providing a service to if they want to continue to provide those services and they rely upon them saying, yes, you can continue to provide those services? It just doesn't happen in the economy. And I know that's probably not a direct answer to your question, Linda, but the reality is that people will fight for the preservation of those agreements. It does end up in litigation, and the composition of a committee changes more frequently than the composition of a board of directors of a caretaking company.
Well, and it appears to us that QCAT is very supportive. Yeah, QCAT is very supportive of people with caretakers agreements.
I mean, QCAT consists of a lot of different members, and different members will have their own backgrounds and whatnot. But the reality is that the weight of cases have been in favour of the preservation of caretaking agreements. And there's a really good academic article that was published by Dr. Melissa Pocock a few years ago, looking at body corporate termination rights, that ultimately concluded that the legislation, the legal system is preferencing the commercial interests of developers, caretakers and financiers over lot owners.
Correct.
Alison, I'll come to you in a second. Jason, can we get rid of section 126? Can we do that since we're going to be looking to change the legislation?
I don't think we here can. I'm not the Attorney General and I don't control Parliament. Anything can happen when it comes to legislative change, as long as it passes Parliament and passes the tests that they impose on them. But I think if you have caretakers put skin in the game, if they have to mortgage some other interest that they've got, if they've got to mortgage their home, they might want to avoid litigation. They might want to avoid the possibility of their biggest asset being destroyed and some other security interest, whether it's their home or some other investment being called upon for it. You know, there was a district court decision of Palm Springs Residences that was handed down like 15 years ago, and it paved the way for the caretaking agreement at Palm Springs Residences on the south end of the Gold Coast to be terminated. And there, the district court judge sort of said, look, you've come to me and you've said that this is a substantial commercial interest that you've got and you don't want me to wipe it away with the stroke of a pen. Well, how about you just do your job? The best guarantee that you've got to the preservation of your asset is to do your job. But I think when you've got something like section 126 there, it's a wonderful safety net. It's a parachute. Yeah. When the going gets tough, they can, you know, back in the old days, like, has anyone heard of over in the American economy where people just handed in the keys to the bank? I don't want it anymore. I don't want the mortgage anymore.
Yes, and during the GFC, right? So, but I think you're right. So we could actually say, instead of having section 126, we could say that in fact there still needs to be the security as per any other transaction, like you said, where there's some kind of mortgage or property that actually then, and I think that's important. Alison, what would you want to say? You've had your hand up. You've been very patient.
Oh, there's another Alison.
There's two Alison.
Yeah. But no? while they're trying to come online, Sam, the one thing that I'd say about that is that if AAA advocated for the repeal of section 126, there'd be some very loud and vocal voices arguing against that. And the simple reason for it is, you know, taking you back to one of the other slides, what are people advocating for? They're advocating for the preservation of value that they have in management rights contracts. And 126 facilitates that value. You know, an asset that has that sort of indestructible security inherently within it is going to be more valuable than an asset that doesn't.
Yeah. Well, I agree with that, but I think at the end of the day, like what we're seeing is a situation where, as you say, it's a parachute, it's a safety net. So there's no need, and that's very interesting what the district, court judge said to that caretaker, like, do your job, right? Like there's no kind of, I guess, consequences for poor behaviour at the moment from caretakers or,
Correct.
managers, and that's what's causing us all these problems. All right, so I'm just going to, no, Alison, we can't hear you.
Can you hear me now?
Yes, we can,
Can
darling.
you hear me now?
Yes.
Sorry, somehow it wasn't allowing me to speak. So
That's
yeah,
okay.
Jason, I'm Alison, one of your clients. You know where we are. So I bought off the plan 6 years ago. I was one of the first ones to sign on to the, I was one of the first buyers. They didn't actually settle until early last year. We're 18 months old. And the first we saw the CMS was after we settled. They literally didn't, we didn't see it till into it. We were told we locked in for 10 years. That's what our real estate agents were telling us, that it was 10 years. And they were, we're told that it was mainly owned occupiers, mainly self-funded retirees. And they locked us into the accommodation module. There's only 5 out of 28 of us that are actually that actually have a tenancy. Jason's firm's actually representing us at the moment because we've got sale of building management rights happening. Plus we've got a stat review and things like that. We actually have trouble getting our caretaker to even clean the toilets in the communal area for, all that sort of stuff. We have difficulties getting him to do just about anything. I like the both sorts of things, like keeping them responsible, but I also I can see their point of view that, that there's money attached to it and there's actually people who are doing the right thing that could be impacted if the agreements got torn up. Is there even a suggestion with the, how you were saying about the ones over 10 years, even actually having them, limited, that, about the extensions, that actually having them limited, that where you've got your 25 years, maybe a suggestion they can't have an extension then because they've gone above and beyond, not giving them the extra bit, is it a case that we'll be locked into the old scheme about extensions too, or is it a case of the proposal is they just literally can't get another extension? They've got 25 years, so they wouldn't be, is there even that thought on the cards? Or,
well, I would be advocating for that, Alison. Yeah, I think that if they've got 25 years, that they're not to be asking for a top up until they basically get down to that, between that 3 to 10 year time frame. And I would be even inclined to say that if they're asking for a top up, the top up would be 2 years, not 5 years.
Yeah, well, we're only 18 months into 25 years, and you know what I mean, and we're already having trouble. So you know what I mean. But we're luckily we've got. I touched base with you about a personal matter for my own apartment, and you put me on to Jason's firm, and they're looking after us for the building management and the stat review, because we simply wouldn't have known about the stat review, and I'm glad that that's there. And I'd hope that going forward that stat review still exists if they're going to limit things, that continues, because it's helping us. We're hoping, we've got our fingers crossed that we get an agreement that's better for us, and we've been represented by the best. But I'd hope that if there are changes, they don't lose that statutory review. If it's going to be limited, there still be that statutory review in there at the best. And like what was said earlier, we should be seeing it. If we're buying off the plan, we should be seeing what the agreement is going to be. We didn't get that. We were told 10 years. We were told own occupiers, and we got locked into something that. One of the actual things is we've got room service and everything that's apparently in one of the clauses in our agreement that was picked up during the recent review. Well, my thing is we can't even get the toilets cleaned for our contract, as contractors. Should we be ringing up and organising room service, asking for tea and coffee, see what our building manager does? Because we've had emergencies, and his response back is and he actually needed to call emergency services and hasn't done it. So I know I'm going off on a tangent. I'd like to see that maintain that statutory review, and I'm glad to see that going forward people aren't hopefully aren't going to be locked into anything more than 10 years. And I like what was said about, that, the majority of owners and that the majority, 2/3 majority in that for an extension, and that if more than 25% are against, they can't have it, because, I think those are essential to protecting owners going forward. So yeah, thank you. Sorry for going off on a tangent, but I think that those to me are the important things. We're in the situation we're in, but those are the important things going forward for owners, I think.
I agree.
To follow up on that, one of the other industry associations is advocating for just one change, and that is that every 5 years, these long-term management rights contracts need to essentially go through a market review. So you have this statutory review every 5 years. My issue with that is you can review a written document to the nth degree. It's not going to change how people are going to behave.
Yeah.
If you still preserve the capital value in the contract.
So
Chris,
currently there's no review though, is there? Currently there's nothing.
There is a 3-year review, but what we're also advocating for is it's mandatory. So it has to occur. So that's your get out of jail free kind of card.
Right.
Chris.
Hi, Sam. Hi, Jason. I guess, firstly, apologies, I was a little late to this session, but I guess the slide that's up at the moment, what resonates me probably the most is points 2 and 3. I think I'm relatively new to being a strata owner. I've been in about 18 months now and on the committee for just over a year. And I was shocked that there is no qualification or any training to be a caretaker or a building manager. And you're right, it should be seen as a profession because there's a lot more to it than pushing a broom around, and there should be some rigor around actually being able to have qualifications for the role, but also, I guess, a mandatory review of caretaking agreements with a firm job description, specified hours of duty, KPIs, perhaps even a bonus structure, or dare I say a malice clause, just by nature that ours is 20 years old. It refers to pages, being contacted by fax. It's very ambiguous in terms of working hours and versus availability hours. And we're actually working with Jason's firm at the moment on a bit of a dispute in the definition of available versus working. So I think those are certainly very important factors. And likewise, a proper complaints framework or a performance management structure as well that actually does hold these caretakers accountable, because they should have a vested interest in performing, because ultimately they have financial skin in the game.
Yeah, I agree with you. And I've just seen from Alison that it needs to be qualifications from independent authority. Like if you're a real estate agent, you have to be licensed, right? And you're regulated. If you're a lawyer, you have to be, licensed. And so the same kind of situation should be occurring. And really, ideally, what I would like to see is the building managers actually have some kind of building nous, right? The number of times that I've heard of case studies where, in fact, what they've done is the building manager doesn't even know what they're looking at in terms of defects. Like you're meant to actually have someone with that skill set within your organisation, right? So, all right, I'm just.
That's an important word, Sam. Skill set, certainly.
Yeah.
I think how many times has a building manager or a caretaker gone like, this is the problem? Say, well, is that an expert opinion or is that your unqualified opinion that we need a structural engineer or that sort of thing?
Yeah, and that's right. We don't want them to be actually necessarily palming it off onto somebody else. So, Jason, I'm going to ask you to go to the next slide just because I'm conscious of the time. And this has been a great discussion, everybody, and I really appreciate your input. But certainly, if anything else comes to mind with you over the course of the next couple of weeks, please email me. We are going to start getting active. I do believe in a grassroots style approach. And, at the end of the day, if our politicians are hearing from apartment owners saying this needs to happen, and we're happy to spearhead that, then something has to happen, right? At the moment, what we've actually found is that the apartment owners haven't been represented, but we're here to do that. That's our job, is to represent you. And you would have probably seen that we had some articles in the Courier Mail recently about management rights. So we just need to kind of keep that pressure up. So letters to the editor, letters to your politicians. I know it's going to take effort and time from your behalf, but this is too important not to do something about. Does that make sense? So just quickly, on the 20th of September, we've got a session about how to create harmonious communities. I don't know how many of you would like to actually have that within your community. And on the 29th of September, we're looking at environmental initiatives in apartments. So if you would like to join us, certainly I will make sure that you are uploaded onto our system if you're not already members of ours. And so we will receive information about our events and also our e-news. And Jason, the last slide, please, if I could. So I would like to thank Jason. Grace Lawyers is a sponsor of the Australian Apartment Advocacy, has just come on board in the last month, which is fabulous. And certainly we couldn't do what we do without our sponsors. And as you can see, Jason and I are very much alike. Two very determined people to create change in a situation at the moment which is relatively, I believe, unfair. And certainly whatever we can do to help you in a situation, please come to us. Please contact us and let us see what we can do to help you. We often act as advocates with developers, builders. Kelly knows that. I know she's on the call. And we certainly would be happy to help you. So please reach out to us if you need any assistance. Last slide, please, Jason. Any last words from you, Jason Carlson, before we sign off for tonight?
Yeah, I'd just say support the organisations that are supporting you and your fellow committee members and lot owners, because I just want to endorse what Sam said. Hitherto, lot owners in Queensland have not had a very effective voice that's gotten through to the right people. And the best thing that you can do is support these organisations. I think membership to nearly all of them would be free. And on top of that, share your stories. Give them something to advocate for. And the final thing that I'd encourage you to do is write to the Attorney General of Queensland. Literally, it will only take you 10 to 15 minutes. Write to the Attorney General and thank her and her team for having the courage to actually open the door to reviewing this. You know, if you give that sort of positive feedback, you might be surprised at how just saying a thank you might stand things in really good stead over the next year.
Listen, I agree with Jason. She is being courageous, and there's no doubt that she will receive pressure from others to not do this. But I do know for a fact that whenever I need to have change, sometimes that politician only needs to receive 200 or 300 letters, and suddenly they realise that there's a whole different scenario happening out there than what they might be hearing from the lobbyists. Okay, so I concur with Jason. If you need the Attorney General's email address or her policy advisor's email address, please contact us and we'll be more than happy to supply that. And when I meet with Finn next week, I will certainly let him know there's going to be some emails coming his way. So thank you, Jason. Thank you for your time tonight. It's been invaluable, as always. Your understanding about this topic is supreme. And I'm very grateful for your support. And everybody else, thank you. Enjoy the rest of your evening. And I hope that we will see you at one of our other upcoming events. And certainly once I'm back in Queensland, we'll be looking at doing a lot owners conference. And I can tell you now, management rights will be on the agenda. All right. Good night, everybody. Thank you for your time tonight.
Right. Thank you.
Thank you.
Thank you.
Thank you. Thanks very much.
Bye now. Thanks, Jason.
Thank you.